So good morning, everyone. It's good to see you again this morning. Welcome again to the Bingham Centre and on behalf of CELI and the University of Leicester. And we continue to thank our sponsors from the AHRC for today's event, which is a continuation from yesterday's event. And thank you once again to our organisers for helping us and our partners for helping us in these matters. I think we'll get straight down to business today because that's what we're here to do. So we have a first panel under the title of the role of the ECHR, mechanisms, remedies and constitutional resilience. And we have 4 papers to come. I hope you have access to the programme, which is available online, as are the documents, other documents such as the biographies online. We have 4 papers to come. The speakers will speak for up to 15 minutes or so, and then we look to have a Q&A afterwards. I know the papers will be excellent, and we have in mind the possibility we hope to take forward what's occurring over these 2 days as a project and the possibility of publications coming out from that. And I know this will be an excellent start to that end today, as was yesterday. But without further ado, let me pass over to Alain, if I may, Dr. Alain Zysset of the University of Glasgow. He's a reader in public law there, University of Glasgow, specialising in the normative analysis of jurisprudence with particular reference to the European Court of Human Rights. His full biography is in the documents I mentioned earlier, and we are especially looking forward to his forthcoming book entitled Responding to Authoritarian Populism at the European Court of Human Rights, a Calibrated Framework, to be published by CUP in the new year, I understand, January, I understand, he tells me. We look forward to that. His paper that we'll now hear is entitled Resilience Without Infrastructure, ? Assessing the European Court of Human Rights Procedural Safeguards in the Age of Authoritarian Populism. Over to you, Alain.
Thank you so much, Ed. Maybe I should, can I borrow?
Oh, of course, thank you. Thanks for doing that.
All right. Well, good morning, everyone, and thank you to the organizers for having me. Indeed, this presentation is going to be, I'm going to try to give you a few insights about my book, my forthcoming book, which is, there you go, here's the cover. I'm going to jump, I think, quite a few times between different steps that I make in the book, but hopefully steps that will be relevant to the topic of this conference. So what I want to do is to actually talk about populism, because populism is this term that everyone uses these days. Since I was also trained as a philosopher, I'm interested in what it is and how can we define it, and then how can we observe the European Court of Human Rights engaging with authoritarian populism? Has the court responded to it? Should the court respond to it? These are the key questions that I tackle in my book. So I'm going to introduce authoritarian populism as a discourse. So how, for example, populist parties understand their political ideology in populist terms on the one hand, but more importantly, perhaps, I want to talk about populism as a practice, because in the last 10 to 15 years, more and more governments have engaged in what we can qualify as authoritarian practices. And I think this is very relevant to how the court is going to respond to these practices if eventually there's a case that comes to Strasbourg. And then I will focus on 2 cases or two countries which are known for having experienced authoritarian populism in the last 10 to 15 years. And then very finally, this is perhaps the key insight of my book, is that I try to modify at least a key tool of the European Court of Human Rights that I think could better respond to authoritarian populism, and that's proportionality analysis. Okay, so these are the key steps. And again, I'm going to try not to jump too much between them, because I want to give you a snapshot of the project. But of course, if you feel that there isn't enough, you have 300 pages in the book available next year. So one of the key questions that I think we need to answer when we talk about populism is not only to define it, but also to say in what ways it is problematic. So what is the baseline for us to then say, well, populism is a problem in the first place, instead of just assuming that it is a problem. And in the book, I focused on two elements of that. The first is that in the populist discourse, we have a very strong antagonistic relationship between the people and the elite. This is very structuring in the populist discourse. And the boundaries between these two groups are, to some extent, it's not possible to overcome that populist discourse. These are settled boundaries. And why is that a problem? Well, it's a problem because it makes democracy and the democratic process largely redundant, because democracy is supposed to actually determine a sort of overlapping consensus, to speak like John Rawls, in terms of finding terms and reasons for our shared terms, our shared political settlement to be justifiable to all. Okay, so I use democratic theory and also broadly a liberal school of thought to explain what's problematic about authoritarian populism in the first place. So there's also a great book by Christian Vosborg, if you're interested, a Danish scholar, that really emphasize how the will of the people under the populist predicament is something that is independent from any kind of procedure, whether it's a democratic procedure, but also to a large extent independent from a legal procedure. So it's a procedure independent concept. Okay, so this is the snapshot for the theory bit of the presentation. What is more interesting, I think, is to study how populist governments behave. So what do they actually do when they get to political power? And that's the second step in the book. And I also make a key distinction here, which is that on the one hand, we know that authoritarian populist government can attack particular groups and particular individuals that to some extent are considered threats to the will of the people. So we know, and that's also very clear in the case law of the European Court of Human Rights, that sexual and gender minorities, refugees, dissidents, and judges are these groups that are distinctively attacked by particular policies of authoritarian government. But the key move that I make in the book is that I think that's not enough. It's not enough as a picture of what authoritarian governments are doing, because I think they also go for what I call infrastructure. So infrastructure is basically the background conditions or the prerequisite for individuals to exercise their right. So we talked yesterday a lot about having an independent judiciary as this kind of background institutional condition. But in the book, I also very much investigate the media system and the electoral system as these sets of background rules and requirements and institutional safeguards that are necessary to exercise our rights. And I think authoritarian populists, because they're eroding the infrastructure of democracy in a very insidious manner, not necessarily in a direct coercive manner. And the key question of the book is, I think that the European Court of Human Rights has addressed the first kind of attack, so the more direct and coercive on particular groups and individuals. But the key problem is that I think it hasn't yet had enough of a grasp of how authoritarian populist government attack infrastructure. So this is the more empirical bit of the project, because I use the work of constitutional scholars, political scientists, sociologists, to show the effects of authoritarian populists on this background infrastructural prerequisites. So having all of that in mind, then of course the key question is, how is the court apt to detect and respond to what I call infrastructural erosion? And I think there's one type of obligation. So moving to the case law of the European Court of Human Rights and the different kinds of obligations that it derives, I think procedural safeguards are interesting in that respect. They're interesting because they precisely talk about the institutional implication of requirements that should go with rights. So typically, the court makes distinction between the substantive and the procedural arms when it is laying out different kinds of obligations that correlate with certain rights. And in the case law, what is interesting, also to a large extent, I think problematic, is often that the court is going to actually focus on these procedural safeguards at the expense of the substance of rights. And that speaks to something that we heard yesterday from Robert's panel about the age of subsidiarity. So instead of assessing and adjudicating the merits of an application, it's only going to look at whether certain procedural safeguards were in place. Okay. So these obligations are key because they're key to the current age of subsidiarity. And in the populist context, the question is, are they enough to actually tackle infrastructural erosion orchestrated by the populists? So moving on to two sort of case studies that have been qualified to governments, to contexts that have been qualified as authoritarian populist in the last 10 years. I move to this key case of Coraccioni and others against Hungary. So I can only skim through the case. What is interesting about it is that we are talking about an opposition MP in the Hungarian parliament. This opposition MP actually happened to be the mayor of Budapest. I'm not sure that that's still the case, but he was an important opposition politician in Hungary. And what it did with a couple of other people in parliament is to disrupt parliamentary proceedings, because they did that through the use of alternative means of expression in parliament, such as, for example, using a megaphone to make sure that they are heard. And of course, that was disrupting parliamentary proceedings. They were subject to a disciplinary procedure as part of the institution of parliament and the rules of parliament. And they contested that that was a violation of their freedom of expression when the case finally reached Strasbourg. What's really interesting about this case from the perspective of authoritarian populism is to ask whether parliament being under the control of the two-third majority of Fidesz, whether the court has really examined these procedural safeguards. So when this journalist was subject to, he's not a journalist, he's a opposition politician, but it was under Article 10 of the European Convention, whether the procedural safeguards were sufficient for these particular individuals to claim their rights. So you can see whether the restriction was accompanied by effective and adequate safeguards against abuse. And what's so interesting here is to just notice that the court only posits two key requirements as procedural safeguards: the right to be heard and the obligations for the government to state reasons for the interference. Okay. Now, this is minimalistic. It's minimalistic because the court is not, for example, going to look seriously at the reasons why these opposition politicians basically used very radical means of expression to bring something to the attention of our parliament. So, for example, the court did not look at the wider infrastructural context, essentially that the government had moved the disciplinary authority in charge of imposing disciplinary sanctions from an independent and pluralist committee to a parliamentary supermajority. So you have a process of capture of parliamentary proceedings here that I think is very much in line with this idea of infrastructural erosion. The court does not look at that. Okay, so in that respect, the court, I think, is not sufficiently tackling the question of these institutional safeguards. In a similar way, the court did not look at a key motive and a key reason for why these opposition politicians did use this alternative and disruptive means of expression, which is that they have said that the audiovisual media, the media system in Hungary, is also under the full capture of the government. So that's also an infrastructural concern that is raised by the applicant, but that the court refuses to look at seriously. It's just basically imposes a very high burden of proof to show that it would have been really necessary for these opposition politicians to use disruptive means of expression. So one example where I think that in this authoritarian political context, these institutional safeguards are not enough. And very quickly, the second context of Poland, where, as we saw yesterday, and there are plenty of cases now at the European Court of Human Rights about the independence of judges and ways in which the Polish government has arbitrarily dismissed some judges, especially, and that's the case of Justition, when a judge was actually trying to assess the legality of the mode of appointment of those fake judges, as we discussed yesterday. And what's really interesting about these cases is that in that area, in that domain, the court did engage in what I would call infrastructural reasoning, because it did look at the National Council of the Judiciary as this infrastructural institution that is in charge of the appointment of judges. And the court actually went into a more holistic assessment of the current situation in Poland and the ways in which the government has eroded judicial independence as a whole, as an ecosystem. So on that front, I think the court is doing a better job. Now, to just finish in a more systematic manner, the book is trying to look particularly at the proportionality framework, which is a key tool of the European Court of Human Rights, especially when it comes to qualified rights, as you probably all know. And I think there's a key stage of the proportionality test that is not seriously looked at by the court when it comes to these questions of infrastructural erosion, in the sense that the court does not systematically look at the aim of the government restricting rights. So the aim that is presented by the government to the court. There is some evidence, and the case in Poland, I think, illustrates that, where the court is indeed going to look a little bit more holistically at what could actually be the aim or the objective of the government in restricting rights. But in a vast majority of cases, the court is basically just looking for one of legitimate aims for restricting these rights. It's actually sometimes replacing the government in actually finding that aim. And I think that's very problematic, because a key maneuver of authoritarian populist government is to run institutions and processes against their very purpose. And that makes the legitimacy or the legitimate aim, which is the third stage of the proportionality test, extremely relevant. I think I would stop there. If you, again, I just want to say, if you want more of this, there's a book coming out next January, but thank you very much for your attention.
They say always leave them wanting more, and we do want more. And we look forward very much to your forthcoming book and questions about your paper, which we'll take at the end of the 4 presentations we're having. But in the meantime, thank you very much indeed, Alain. I've had plenty of questions I'd like to put from that very interesting paper. But in the meantime, we move on to Dr. Mariam Begadze. I hope I'm not mispronouncing that too much. Forgive me if I have. Who obtained her doctorate, as the bio online details say, from the Central University Central European University recently in 2024. She, I think until recently, was a research assistant at CEU, Democracy Institute and Rule of Law, but you may want to update us on that in a minute, you were saying.
Will be also starting from this month, I will be back because I was also a research assistant before and will be for some time again. Yeah.
Okay, well, thank you for clarifying that for us.
Yeah.
Your recent publications include a study of illiberal strategies deployed against opposition-led local governments, published in the Hague Journal of the Rule of Law, and an analysis of judicial review over pretextual rulemaking in a handbook published by Edward Elgar. And in addition to your academic work, you litigate cases against Georgia before the European Court of Human Rights in the context of bad faith interferences with rights as well. So we look forward very much to hearing from you, Mariam. Your title today being Activating the European Court of Human Rights Rule 39 as a tool of militant rule of law. So, and just a reminder, if you could to speak to the microphone so our online audience can.
Yeah.
Thank you very much. Over to you.
Good morning, and thank you very much for being here. So I think this is a very good transition to my topic because previously we talked about how process-based review might not be adequate in states in which, for instance, independence of courts, one of the key structural unit of this infrastructure, is missing. And I will move a step further and state that temporal issue is also very important. And this is coming from me as someone from Georgia, the country which is undergoing the most rapid autocratization that I've seen until now, having worked on these issues. Therefore, is the topic of Rule 39, which I think in many situations is the most adequate and also most pragmatic solution to many of the doctrinal dilemmas that emerged that we also discussed yesterday, but I will reflect on that better. I will just, to be on the same page, I will just state very shortly that Rule 39 is one of the rules of the court, which states that in exceptional circumstances, the court, upon application of the parties or upon its own motion, will use this interim measure in cases when there is imminent risk of irreparable harm to a convention right. And I would probably add here that maybe to a multi-layered system of the convention as well, because when the infrastructure is missing, especially the judicial independence or civil society, then of course it's even a bigger threat than an individual right. So my argument is twofold, and one leads to another. First part of my argument is that there's already a process of expanding Rule 39, and that is both in terms of scope of cases to which it applies and to the substance of instructions that the court gives to the states. And then I will add to my argument that as long as it's already an ongoing process, why not accelerate it or doctrinally reinforce it so that it becomes actually effective, or at least plays a role of a speed bump in this process. We know that no court, no infrastructure can completely stop it, but at least it can gain time and give this time to the society, a civil society that is fighting autocratization. And I will also add a disclaimer that I'm not arguing, even though I offer today some doctrinal guides, I don't argue that there needs to be a change to Rule 39 in terms of requiring that these decisions are reasoned, because I think there is a valid, legitimate reason why the court decides not to provide reasoned judgments on that. That's precisely to guarantee its swiftness in these circumstances. But despite that, I think that the court needs to have some doctrinal framework which it uses to first support its arguments, and then choose the cases in which it uses these exceptional measures. So now to move on to illustrate the first part of my argument, on how the shift has already occurred, you can see this in this table, that the most famous examples from Rule 39 is the non-refoulement cases in which extraditions have to be suspended so that the person doesn't, the individual, so those orders were very individual in the sense that there was a very concrete threat or torture or death or flagrant denial of justice. This was the standard case in which the court would use Rule 39. But this has changed, and now we have situations in which this individual right to life, Article 3 threats have become more generalized. For instance, and the examples are in 2025, for instance, it was used against Serbia in a case in which there was so the assembly dispersal techniques were used, the sound device was used for it, which is bad for health. But even though the court didn't even have time to establish whether that has occurred, the court still stated that nothing of that kind may be used in the future. So as you see, there are conflict situations, so state to interstate applications also being subject to interim measures. In Navalny case, also access to medical files or selected doctors' access to the patient. So the health categories has also expanded in this sense. There is so the court used to reject interim measures for party dissolutions, for instance, but now in a very unexpected case also against Georgia, Rustaviori case, in which violation was not found or merits later, but interim measure was used to stop the change in editorial policies in any manner. And the similar things have happened against Ukraine when the court said that journalists' sources need not be accessed, shouldn't be accessed within the criminal investigation. So no data should be accessed because it's a journalist and it has a different kind of level of protection. Also in eco-defense, although quite late in time, because the first application was filed in 2013 and the first interim measure was used in 2021. So, but the court did start using it against NGO dissolutions when it became pretty certain that there were court orders against these NGOs. And then it became easier still against Russia in Novaya Gazeta case. So that happened a bit faster after the first application was filed and the court used interim measures. So we see this change. And another very important change also in terms of the infrastructure that was discussed here is that while it was rejected in 2020 to use interim measures in cases against judges in Poland, so when the disciplinary measures were used against them to stop those, in 2022 already 25 interim measures were issued in multiple cases that were filed before the court. So you see the shift. And so I hope that I convinced you in my first part of the argument that as long as there is already a shift, why not accelerate it and strengthen it so that if the court receives backlash, at least it's not for nothing. Now with the second part of the expansion, you can see how the wording has changed. So you can see that the decision should be suspended, so there is no interference in editorial policy in any manner. So any of the data should stay out of police interference. Then in Novaya Gazeta, you see that any action shouldn't be taken that would deprive this organization of its enjoyment of its rights, which is also broad, not a specific state action. And also in a bit odd way, you can see that the court even says that state should suspend the decisions of transfer of judges. So it's a bit of a remedial action, not only interim measure, but something that has already happened needs to be stopped. And the last one, I already talked about it, that what is distinct about this case is that the court lowers the evidential bar because it says that I don't even have to be sure that such measure was used because I don't have time, but I'm telling you that in case it is going to be used, it will violate the court's interim measure. Now, the core, so the second part of my argument is the core of it. And what I argue here is that there are already doctrinal bases. So there are embedded doctrines in ECHR jurisprudence, which can be used by judges that decide, by single judges that decide these interim measures to guide them in selecting the cases in which they will use it. So the first part of this four doctrinal guides is the administrative practice exception, which means that the court has the admissibility standards you all know, and one of them is the exhaustion of domestic remedies. And the court will say that no applicant needs to wait this time and exhaust remedies when there is clear evidence of repetition patterns, so there are repetition of acts, and there is official tolerance. So the official high-ranking officials cannot hide behind subordinate states that saying that they don't have power to control them, and this pattern is beyond their power. So, for instance, I can give you an example from Georgia that there is plenty of evidence to argue that there is administrative practice of violence, for instance, because those involved in violence were awarded by the president. So you can say that there is official, this is the evidence of official tolerance. And the logic of this administrative practice that court thinks it needs to act faster when there is this official pattern, systematic nature, and official tolerance is something that could be used by the single judge deciding the case. Also, the court already has this idea of potential victim in cases, and there's this famous case, SAS against France. I know it's a different context, but the idea also in ECHR and Novaya Gazeta, you can see this idea that sometimes laws don't have to be used to attack your rights, because if you start self-censoring yourself or it's stigmatizing like the foreign agent laws are, then it's already a problem. So in interim measure proceedings, the courts can use this argument to start using it even before actual individual measures are taken against the NGOs. And in this aspect, I would also add that its own experience with Russian foreign agent laws can be an additional argument why it's accelerating its response, because it already knows that what the end point of all of this is. Then the third doctrinal guide that I suggest needs to be used is this chilling effect. Doctrine of the court, which is very often used in different rights contexts, and it's in a way also connected with the potential victim standard. So that's two sides of the same coin. What is interesting is that with chilling effect, now you see the court saying that this is not just some neutral result or consequence that we are getting, it's an intended state action to cause chilling effect. So that's also a change starting from eco-defense, that in eco-defense, while it was neutral in terms of what the subjective motives behind this chilling effect was, in Kobalia, after 2 years, it already states that it was actually intended. And the last and the part, my interest is a lot about adjudication of bad faith state action. So the last part concerns that the change in jurisprudence, that has taken place since Merabishvili against Georgia again, is very important. So the court has lowered the standard, and it states that the states might be in violation of Article 18, which states that the known right should be restricted with an ulterior purpose. These violations can be established without having so with the standard of beyond reasonable doubt, and this standard can be satisfied with the following kinds of situations. For instance, coexistence of sufficiently strong, clear, and concordant inferences. So unrebutted presumptions of fact, even without direct proof. There is also a very interesting case against Turkey, Selahattin versus Turkey, in which the court also refers to the changes which have taken place in terms of judicial independence, and states that because of the public statements made by the president, and because how vulnerable the court is, these statements even need to be more feared, because and for that, in that case, the court has this convenience to talk about constitutional amendments which have affected judicial independence. And the third subtle category which emerges is also that if the more unreasonable the state action seems, for instance, if there's a lapse of time between the things that have occurred, the acts that have been committed, and the investigations that have been started on a specific case, so this manifest unreasonableness could be taken as evidence of bad faith. So single judges deciding interim measures can always refer back in their minds, because they don't have to reason the decision, but that's how they can guide themselves to choose the cases, so that Rule 39 remains very exceptional, as it was intended to be, but also becomes effective. And last but not least, I think that another long overdue theoretical framework that we need to tackle illiberal regimes and how they destroy democracies and constitutionalism is militant rule of law and constitutionalism. First of all, it's nothing, it's not anything particularly new. So we already have these militant aspects in constitutions. For instance, term limits is one of the examples, but it has to be reinvigorated. And also there was a discussion about UK common law, and I think that reasonableness in itself is as basic as it seems, is actually something that if you use it creatively, you don't need to invent something new, and that itself could be a tool of militant rule of law in many circumstances. And that even goes beyond rights, as we said, because you can use that standard without rights being affected. And there are plenty of examples, both in UK context, and I would suggest also South African constitutional law. So just to place my argument within this new framework, I would say that this quote might be of my supervisor, ex-judge Andrei. This quote gives me reassurance that interim measure does belong under this theoretical framework, as he says, given the potentially irreversible consequences of illiberal democracy on constitutionalism and democracies, morally imperative to consider to what extent the arsenal of preventive measures should be applied to counter the current trend. And just reflecting on yesterday's conversations, I would add that this doctrinal, this legal dilemma that we are facing, that we have defective judges and defective decisions, could have actually been avoided if interim measures were used more proactively before. Thank you.
Thank you so much, Mariam. And we're reminded, of course, we are celebrating the 75th anniversary of the convention, and undoubtedly the convention was established as a so-called alarm bell for democratic Europe, wider Europe now. I'm reminded the first draft of the convention specifically had, I think, interim measures within it, and was designed to prevent any regression of the existing democratic standards that the states had. This was the time of the Cold War, of course, and in the late 1940s. Enough of that. More important issues to discuss now. We've had two great papers that are so relevant to the current situation of the court. And it goes without saying, I think this brings us to the third paper, which is very much so, and in a wider context as well, as we're about to hear. So I'll now introduce Dr. Kirsty Hughes, if I may, who's an associate professor in human rights law at the University of Cambridge. Details, again, are online in the bios, and a fellow at Clare College. She's a general editor of European Human Rights Law Review, as I expect you know, amongst other things, and she's director of the Centre for Public Law at the University of Cambridge. She also has a book that's forthcoming, not quite out yet, with Cambridge University Press. Is that right? No, it's out, I think, isn't it? It's out. The title of that is, if I find it here, well, you tell us the title, if I could ask you to.
Yeah, of course. Human rights law in the UK.
It is. It's stated here within the bio. Thank you so much. But I'll stop confusing matters. Let me just introduce Dr. Kirsty Hughes for you. Her title is Migration, Resilience and the Rule of Law. Over to you, Kirsty.
Thank you.
Thank you very much for that very kind introduction, and also to the organizers for putting on such a fantastic event. I'm really very grateful to be here. So I'm going to talk about migration, resilience, and the rule of law. Immigration is one of the most politically charged aspects of human rights law, where the rule of law is most tested. It's often the impact of borders and nationality that creates the crucible for rights violations. But of course, the convention was not drafted with migration in mind, and so obligations to permit non-nationals to enter or to remain are often seen as extending the convention and the role of the European Court of Human Rights far beyond what states agreed. Backlash against the European Court of Human Rights is therefore heavily driven by migration case law and is often a direct reaction to it. This is not a new phenomenon, but it is, I would say, an escalating one, an example of which was, of course, the UK's response to the court's interim measure in respect of deportations to Rwanda, and a decision that led to renewed threats to withdraw from the convention. Immigration was also one of the key bases on which the Conservative government sought to repeal the Human Rights Act and replace it with a British Bill of Rights. They argued, amongst other things, that Article 8, as interpreted by the court, prevented them from acting in the public interest. Now, given the political sensitivities, the European Court of Human Rights strives to strike a delicate balance in protecting rights while also respecting state sovereignty. It's not unusual, in fact, it's commonplace to see state sovereignty emphasized in the court's immigration case law, an approach that's long been criticized by both those who believe the court has overstepped the limits of its role, as well as by those who believe it defers too readily to states. And the latter argue that the court prioritizes state sovereignty over and above the rights that it purports to confer on migrants, and that renders those rights meaningless and also legitimizes state practices. So those tensions are escalating both domestically and internationally in relation to migration issues. And the outcome of this is likely to be indicative of the resilience of rights. So in this brief paper, I'll examine some of the evolving issues, considering that resilience and the fragility of rights. And there's two planes that I'll examine it from, the domestic plane and the international. At the domestic level, the Conservative Party have recently announced their plans to take the UK out of the ECHR if they win the next election. That follows from the Wolfson report, in which Lord Wolfson, Shadow Attorney General, provided what's described as legal advice for the leader of the Conservative Party. That advice is structured around a series of tests that were promulgated by Conservative Party leader Kibi Badenoch as the means of deciding whether the UK should remain a signatory to or withdraw from the ECHR. And the framing of those tests, I would say, is somewhat problematic in the context of legal advice that's been published to the world at large. The choice and framing of the tests is, of course, political, and the interpretation of the outcomes of the tests is equally political. They are clearly not legal tests, they are political goals. The tests or goals upon which the Wolfson advice is framed reflect those set out by Kimi Badenoch in a speech in June 2025. The first of which is framed as the sovereign borders test within the report, although it had been previously termed the deportation test. And that shift is indicative of an expansion of the parameters because it now encompasses issues such as family reunification that wouldn't have come within deportation test necessarily. And we'll see the significance of that in a moment. In respect of the sovereign borders test, the Wolfson report concludes that the ECHR sets limits on the UK's ability to control its borders. It suggests that leaving the ECHR would not only expand the UK's capacity to control its borders, but that the UK could, free from the purported constraints of the ECHR, adopt more robust policies in this area and still, and this is a phrase which is repeated throughout, maintain compliance with other international instruments to which the UK is signatory, such as the Refugee Convention and the Convention Against Torture. And this wording of maintain compliance is something we see throughout, which obviously contrasts quite sharply with being compliant. The report cites Australia in support of this contention to suggest that Australia's immigration laws, policies, and practices, which include offshore processing and mandatory indefinite detention, comply with international rights instruments, is, I would say, incorrect. The Human Rights Committee and the Committee Against Torture have concluded on a number of occasions that various of Australia's immigration practices violate core protections. And perhaps most troubling, I think, from a rule of law perspective, are extracts such as the following. So at paragraph 73, it states that where there is no body capable of providing a definitive conclusion on the interpretation of an instrument, the UK will be in a better position to argue that its actions and policies are compatible with the instrument in question, provided it has bona fide opinion as to the meaning of the instrument. The Wolfson report goes on to state that this in part explains how the Australian government maintains that its border policy is compliant. As a result, its position cannot be authoritatively second-guessed in any competent international court. The Wolfson report thus concludes that by withdrawing, while the UK would be subject to the Refugee Convention, there'd be no risk of a supranational body issuing a binding judgment. Again, Australia is referred to in this respect. And these repeated references to maintaining a position of compliance, as opposed to being compliant, highlight the risk of venturing into a sort of world of Humpty Dumpty here, where states can maintain that words mean what they say they mean. Something that we saw, I think, in respect of the Safety of Rwanda Act. And that is quite clearly problematic from the perspective of the rule of law. The other issue I want to highlight from a rule of law perspective is the way in which the current legal position is presented. In an excellent report for the Bonavero Institute, Victoria Edelman, Alice Donald, and Bashat Kali have examined the ways in which immigration law and human rights are misrepresented in public debate. And they focused on media coverage and found widespread misreporting. I have similar concerns about some of the discussion of immigration cases in the Wolfson report. The first of which is the way in which the report discusses the right to respect for family life. The Wolfson report states, at paragraph 45, that courts have given an extremely broad interpretation to the scope of the concept of family life, to include relationships between siblings, including adult siblings, aunts or uncles, nephews or nieces, grandparents and grandchildren, while close relationships are generally considered to fall within the scope of private life. Wolfson report states that the problematic effect of this is that it provides first-tier judges with a broad margin within which family life can be found to exist, and a similarly broad margin of discretion. And there are two issues with this. First, the notion that the European Court of Human Rights accords a broad interpretation to the scope of family life in the context of immigration is untenable. This is evident if one looks at the case law of the court and compares it with the cases cited in the Wolfson report. There are three cases cited in the Wolfson report. They are Bouganemi in France from 1996, Boyle in United Kingdom from 1995, and Marx in Belgium, which was reported in the 1979 to 80 edition. All of which are, one might say, historic cases. 2 of the 3 cases are not even migration cases. Boyle was a child custody case. Marx was about state recognition of the relationship between a mother and her child. Uganemi did concern migration, but it dealt with both private and family life ties, and the applicant in that case had a child as well as parents and siblings. In any event, the court has clarified in subsequent case law that adult children only have ties with their parents where there is the requisite level of dependency. There's been a raft of cases since then in which the European Court of Human Rights has made it clear in the context of immigration that family life is generally limited to the nuclear family. It does not, therefore, automatically apply to adult siblings, aunts, uncles, nephews, nieces, grandparents, grandchildren. On the contrary, the threshold for family life in those cases is very high, and it's centered around the concept of dependency, a concept that is not featured in the Wolfson report. The importance of that concept was made very clear by the court in December last year in 2 cases, Camari in Netherlands, Martinez Alvarado in Netherlands, some 9 months prior to the Wolfson report. But it was by no means the first occasion on which the court had adopted the stance that there can be no family life between parents and their adult children or adult siblings unless they demonstrate additional elements of dependence involving more than a normal emotional ties. In fact, that's a principle that the court has stated for more than 20 years. It can also be traced back, if you follow through far enough, to some of the commission case law from the 1980s. If we look at the case law, we see how high that dependency threshold is. In Savren in Denmark, the applicant who was receiving treatment for paranoid schizophrenia could not rely upon close ties with his mother and siblings in order to establish family life. The Grand Chamber emphasized that the applicant had often lived in care settings and that the illness was not sufficient evidence of dependency. In Centrishak in Finland, family ties couldn't be established between an elderly mother who'd suffered a stroke and her daughter, her only surviving relative. So the position stated in the report is not representative of the position adopted by the European Court of Human Rights. As for the interpretation given by our domestic courts, the only case cited in the Wolfson report is the IA case. This is a case from January 2025, which received considerable political attention after it was embroiled in a sort of back and forth between Kimi Badenoch and the Prime Minister in Parliament earlier this year. The case concerned a family from Gaza that sought reunification with a family member who'd become a UK national, resided in the UK. The UK national was the first applicant's brother. Those seeking entry were his brother, who was the father of the family, together with his wife and their 4 children, who were aged 18, 17, 8, and 7 at the time. They'd sought entry for leave outside the immigration rules, which was rejected by the Home Office and then was taken to the first-tier tribunal. First-tier tribunal found that there was family life, but the weight to be attached to the public interest was not outweighed by Article 8. Upper tribunal subsequently found that there were flaws in the way in which the balancing exercise had been carried out. They therefore went on to make the assessment and found that there were very compelling or exceptional circumstances. And that decision obviously concerned Kimi Badenoch, and it's not surprising it made its way into the Wolfson report. What is surprising, though, is that despite the fact that the report was published in September, it fails to mention that permission to appeal was granted by the Court of Appeal in May 2025, precisely in order to enable the court to consider whether family life could extend beyond the core family. And this kind of use of case law to make the case for withdrawal is, I think, reminiscent of issues we saw in the Bill of Rights consultation a few years ago, where again, immigration was targeted, and again, there was little offered in the way of concrete case law to support claims which were made. Now, while Labour has taken repeal of the Human Rights Act off the table, for now at least, it is reviewing Article 8 to determine whether further limits can be imposed. And a white paper in May of this year indicated that an overly high proportion of family-related immigration cases are now decided on the basis they're exceptional. And so we might expect some proposals for change. In contemplating proposals for change, it's necessary to note that the the domestic immigration law is extremely complicated. The immigration rules are immensely complicated. The Law Commission observed in 2020 that there is a need for complete overhaul in order to promote accessibility, legal certainty, transparency. That's yet to take place. The Supreme Court stated in 2023 that the poorly drafted rules are creating difficulties and uncertainties. So there's no doubt that there is definite scope for reform, but that's a different issue from substantive reform of the Convention itself. And when one looks at the kinds of arguments which are being made in respect of Article 8 and what the European Court of Human Rights does in relation to Article 8, the court has effectively put in place a system of procedural requirements for states, and provided that they follow those and that they apply those criteria, states actually have considerable latitude. That's why we don't see a raft of cases in which violations of Article 8 are found in this context. But what the report is attacking is the very kind of need for those procedural steps. It's one, and that I think perhaps it relates to some of the points that you considered yesterday. So on the question of reform, it's important to observe that there are growing calls from outside the UK for reform as well, which again are driven by immigration. Earlier this year, 9 states issued a joint letter challenging the migration jurisprudence, including but not limited to Article 8. And at the time, the Secretary General responded stating that while debate is healthy, that politicizing the court in this way is not. In a society governed by rule of law, no judiciary should face political pressure. Institutions that protect fundamental rights cannot bend to political cycles. And if we do, we risk eroding the very stability they were built to ensure. Since then, it's been reported that the Italian Prime Minister has proposed a debate on reform. It's been reported that senior officials were going to meet in Rome earlier this week to continue that discussion. The details of this are yet unknown. If there are to be any changes, either domestically or internationally, though, it's important that those changes are determined based on an accurate understanding of the legal framework. And so in conclusion, these challenges in respect of migration are not going to disappear. Any attempts to reform need to be clear as precisely what the legal issues are and how proposed change is going to ensure that we are still governed by law, as opposed to eradicating all such limits.
Thank you very much. Thank you so much, Kirsty, for that great overall paper. But I would say, especially from that powerful rebuttal demolition of Lord Wolfson's inverted commas analysis of the Article 8 material, which gives a kind of legal respectability and credibility to the sweeping claims that I dare say will now be input into, say, those that are supporting the letter of 9. So I can only urge that this is put out into the public domain, or what you're saying here, and perhaps we can that can be part of Q&A afterwards. It was so important what you said. Thank you so much. Let's move on to our next paper, where we'll learn more and I'm sure get more inspiration. So we will turn now to Edward Perez, who's completing his PhD at UCL and who has completed an LLM from Cambridge for that. And his full details are on his bio, again, I refer to online there. His research focuses on the potential legitimacy and effects of the structural remedies issued by the Inter-American Court of Human Rights. And this may bring him to his paper, the title of which I think is on screen, Structural Remedies, Safeguards for Democracy. What can multi-layered human rights protection learn from the Inter-American Court of Human Rights? Edward, over to you, and I encourage you to have the microphone to sort of close proximity. Thank you.
Thank you. And well, I must admit, it's always a little bit daunting to talk about the Inter-American Court of Human Rights in a very European Court of Human Rights Center type of forum, especially because, to be absolutely fair, in many occasions, it's, I think, daunting to even compare between the European Court and the Inter-American Court, mostly because although they are international human rights courts, they follow very different, even philosophies of how they understand international law and constitutional law. The Inter-American Court engages very much with transformative constitutionalism as a framework, so which is something that European states, especially well, the European Court of Human Rights, rarely does. So, I mean, I'm flagging these types of caveats only like to visualize the fact that I understand that there may be limitations on this comparison. Yet again, maybe as Dr. Bates mentioned, it might give some space for inspiration. Because one of the points, and with this I start with, if I can switch this. There you go. I was thinking about how to frame this conversation a little bit more. And of course, we have lots of literature from Germany, Armin von Bock-Dandy, and all of the transformative constitutionalism gang that have developed strong standards on how to incorporate transformative constitutionalism in Europe. At the same time, it's strong inspiration from the Inter-American system. But I'm also fully aware of the challenges from Rosalind Dixon, Tom Ginsberg, on what should be the role of courts, especially when addressing what will be my thematic case study, which is democracy and electoral democracy in particular. But what gave me the firmest inspiration to address this is that maybe 4 days ago or something, and Andreas Follestad issued a new paper, which I frankly loved because in the paper it is acknowledged that, well, maybe to address the issue of authoritarianism, authoritarian populism, we might draw some inspiration from other spaces and from the tools that the other human rights systems have developed. And the one that I will be addressing in particular is the structural remedies, not only because of their potential to address structural failures that lead to the repetition of human rights violations, sort of like the general remedies to some extent in the European Court, but also because they may be issuing them maybe within the European Court's legal authority as understood in these terms. So it's a little bit of exercise of creativity. Of course, yet again, an opportunity. And to address this, I want to discuss two case studies, which are the case studies of Nicaragua and Venezuela, which, as we can see here from the VDEM democracy indexes, their situation on democracy has been diminishing substantially over time. And if we focus on electoral democracy, it goes even worse. To be absolutely fair, in both indexes, Venezuela and Nicaragua are under the lowest 10% of the VDEM democracy indexes. And if we assess the cases qualitatively, what we will find is interesting stories. In Nicaragua, we have in the last 3 elections, the same person, Daniel Ortega, the incumbent, has been winning elections, but in all of the cases with one challenge that has been bigger than the other. And the first one, he packed the courts. He made sure that the courts ensured him that any type of restriction to indefinite re-election was waived. In the second one, he annulled opposition parties, and on the other side, he took over some of the other ones. And on the third one, he simply bluntly started arresting or exiling most of the opposition candidates. And in Venezuela, the situation is relatively the same. With Nicolás Maduro claiming the last 3 elections, with 2 of them actually having strong claims from the opposition candidate on the fact that there was a fraud. And in the last one, actually, the opposition candidate proving that with the ballots, that the opposition had actually won, but still that was not enough to present a claim in a state where both the electoral authority and the judiciary were co-opted by the incumbent. So the interesting thing behind this is what happened immediately afterwards. With regards to the first election on this trend, the one that I just mentioned, in the Nicaraguan case, one of the opposition members presented a claim to the Inter-American Commission of Human Rights, and that coincidentally, just after a few a few months after the election was, the final election, the third one was held in Nicaragua, the Inter-American Court of Human Rights solved it. The same thing happened with the Venezuelan. There's some, with a Venezuelan example that I will be mentioning just in a moment. But let's see how the Inter-American Court framed the remedial part of these judgments. As you can see, they went full on ambition, requiring a constitutional amendment to prohibit a subsequent re-election, ensuring the electoral authorities' independence and impartiality, and ensuring that there was a judicial recourse, a sort of judicial review to address any type of electoral claims. And the same thing happened with the Capriles versus Venezuela case, where the court went even bolder and went on to address remedies, including ensuring electoral integrity, ensuring processes to ensure that mass media had, you guaranteed equitable access to mass media, verification processes of the elections, and of course, ensuring that the electoral authority and the judiciary were independent to ensure their role as guardians of democracy as well. This trend, these very specific and ambitious remedies reflect on a trend that the Inter-American Court of Human Rights has been advancing over time. The red line, and the one that you can see that starting 2010 is always over the blue line, reflects the more specific remedies. Remedies in which the Inter-American Court has not only required the state to address the structural failure that that led to a human rights violation, but also the Inter-American Court went on and substantively made a suggestion, a recommendation, actually more of in a language of an order on how they had to do it, reducing significantly the margin of appreciation that the states had to try to address that, which would be the blue line types of remedies, which, as you can see, have diminished over time. And we can see that in the cases concerning the prior cases concerning electoral democracies. When the Inter-American Court has had to face cases concerning Nicaragua, Mexico, Venezuela, and Colombia in the past, we see that the remedial approach of the Inter-American Court of Human Rights has been mostly on a procedural nature. And in this procedural nature, what they're thinking is, okay, let's make sure that the state has the conditions so that in future elections, things can go better. Clearly, unlike the last two judgments that I just mentioned on Nicaragua and Venezuela. So what I'm thinking is that why did the Inter-American courts shift from these more procedural safeguards before 2024 and going on into this more substantive type of safeguards in which they're going into addressing mass media, number of re-elections that are going to be questioned, and so on. Now, a very simplistic approach to this would be simply to make a reference to the normative framework behind this. And it's that the American Convention on Human Rights is very peculiar, mostly because of its history on ensuring that democracy is at the center of many of the parts of the American Convention. So we have an Article 23 of the Convention that's similar to Article 3 of the Protocol number 1 of the European Convention. We have also a reference in the preamble of the American Convention to Democracy. The OAS system has this very particular Inter-American Democratic Charter, which is, although it's soft law, it is understood to be a quite powerful means of interpretation of the American Convention on Human Rights. But, I mean, to be absolutely honest, simply by mentioning this, we can find parallels also with the European system. And let's face it, it wouldn't be fair to simply justify this normatively, especially when international human rights courts face big legitimacy issues that merge not only the challenges associated to courts intervening in electoral processes, as the Venice Commission flagged regarding to Romania's case, but also because we have claims concerning international intrusion into electoral processes. Because, of course, what is an international institution doing, meddling so much into these types of topics? And we can find many challenges of legitimacy that have been mostly documented in literature, and I won't go that much into them. Just mentioning, well, there is a critique on self-determination, where there's a critique on whether this is an imposition of one specific democratic framework. Is this favoring the US interests? Of course, because we always hear this type of claims. And where does political accountability enter here? Why are courts getting involved in a forum that should be of political accountability? So what I'm going to argue, what I suggest, and I think, frankly, it might be a contribution in general to multi-layered human rights protection, is that in cases of electoral distress, there are two types of interventions in which, through remedies, international human rights courts may should get involved. The first one is a procedural intervention, and this one dialogues directly with the previous presentations, in which the remedial focus should be to promote resilience. We have a weakness on the democracy. We saw it in this electoral process. Let's see how we can build up, how we can strengthen it so that it does not repeat itself. Let's see how we can stop the progressive democratic deterioration that is ongoing. And let's think of the Inter-American Court's role in addressing that. But the one that I think is interesting is the one that's inspired in the Capriles and Gadea cases, which is framing recovery, a substantive intervention. Now, I'm going to, for the sake of time, I'm going to zoom on this one because it's let's say, the more innovative one. And what I'm thinking of in these cases is like, well, remedies can be useful when there is absolutely no expectation of compliance. And remedies can be useful when the state went full on into authoritarianism. In these cases, what I'm thinking is that the legitimacy of the court is grounded not on trying to prevent democratic decay, but actually in trying to frame the path towards a democratic recovery. Of course, this has to be very exceptional. I argue it's a last resort. And what I'm thinking is that only you'd have to find three elements to be able to address this. There's no reasonable expectation of people's will having been respected, or being respected, or that will be respected, which would be to some extent, we already saw the Venezuelan case where you actually had the ballots and still the incumbent is still on power. There is reason to believe that electoral authorities are not independent or impartial, and there is no room for neither judicial nor political accountability. So it's to some extent what political scientists would call a state of full cooptation of all of the institutions. And in this case, the justification of the role of international human rights courts is precisely because they are the institution that international law protected it from being co-opted. The international court would have more freedom from the domestic pressures, bringing it to an interesting point to try to at least address these types of challenges. It acknowledges also that international human rights systems are not decontextualized. They form part of a broader regional system, of a broader regional purpose, which includes usually electoral democracy as a regional concern. And it not only articulates with other international actors that may be pushing for democratic recovery, but it may also support domestic NGOs, giving them language, giving them narratives that can be useful for challenging such situation. Of course, in these cases, as I mentioned before, there's a full acknowledgement that these are remedies that will not be compliant. But building on Paringstrom's work on compliance, well, what I'm thinking is that in these types of cases, compliance should not be our main goal. Impact can be measured, impact of a remedy can be measured in a better way, can be more useful in these types of circumstances, because it can legitimize collective international and domestic action, and it furthermore can provide a roadmap towards recovery of democracy. So the court might then become a more substantive orientator on what's the path once to a transition back to democracy. So to conclude, why I think this is relevant to multi-layered protection of democracy, because everything that I just mentioned, that was the Inter-American Court case, to be absolutely fair, there's no reason to think that is not replicable into other international human rights systems. Actually, it dialogues very well with the presentations that were before me. And what I'm thinking is, okay, how can we justify this without making it, without abandoning the idea of the age of subsidiarity? And it's arguing that, well, subsidiarity is still respected in this context. This is a last resort, but it connects also with one of the final questions that we mentioned yesterday, and it's what does the European Court of Human Rights, what does the African Court of Human and People's Rights do for us, for the people? And in this case, the proposal of this Inter-American Court is at least giving a framework to challenge authoritarianism and go back to democracy. It might not lead to the immediate impact, but it might at least frame itself as also providing legitimacy to the International Human Rights Court, not from the states, but from the people who are the ultimate beneficiaries of this system. And that's it. Thank you.
Thank you very much indeed, Edwin. You asked in the title to your paper, what can we learn from the Inter-American Court? And I think the answer to that is plenty, a lot. And we've learnt a lot as well from your paper. So thank you so much for that, and wish you every success. And I no doubt it will be very successful with your PhD on that. So we come now to the Q&A part of our sessions. And so we welcome questions from here, and there may be some online as well, and I'll look to catch you in that regard. But please introduce yourself when you do ask your question. Try to keep it brief. Yes. If you have if the question is directed to a particular individual, please obviously say so. And a reminder that we are online, so we'll have the roving mic for the purposes of the questions, which will be online, just so you know as well. People online will be able to hear it. So can I look for a show of hands? And we have some online, so you'll need to be quick in the room.
Let's start with the.
Yes, let's go online.
It's a comment really, so it's, and it's from Dr. Liv Gies, our colleague at the center in Leicester, and she says there can also be a positive media framing of migration and human rights in select cases. For example, Ukrainian refugees Windrush scandal. We need to try to understand what is required for positive framing in order to challenge the negative stories.
I'll ask a general question, if I may, particularly focused on those papers which were looking at the role of international institutions in relation to democratic resilience, constitutional resilience, in reference to subsidiarity. So I'm wondering, I was looking at the case law there not so long ago, and the question that occurs to me is timing of these issues. The great disparity between, there has been in recent cases, certainly concerning Russia, between echo defense was mentioned, between when the case was, the application was made to Strasbourg and the European Court finally responded to it. So timing seems to be very important in these matters. With respect to Rule 39 issues, but this is a matter I would ask all to comment on, could the court actually do something to, and you were referring to this, Mariam, I think, reflect that in what it expects of Rule 39 requests? Should the court's criteria not expressly refer to constitutional resilience or democratic decay or words to that effect? I think of the court's priority policy, and that does not refer specifically to anything like democratic decay. So a question initially about timing, the importance of timing, and how the court also may be able to, in Strasbourg, but elsewhere, and perhaps the Inter-American Court is doing things in this regard, highlight in more transparent terms its role here and how it could be made more effective potentially.
Shall we collect a third one?
Oh, I didn't see. Please, Kirsty, you introduce yourself.
Thanks a lot, everyone. My name is Kirsty from Utrecht University. Really enjoyed your all presentations. It made me think a lot in many different ways, also more structural ways, whether the court is equipped to actually deal with some of these infrastructural issues that you mentioned, and the timing which Ed already raised. So it may take years. We may have another pandemic until, for example, COVID cases will be all addressed by the court. And we have seen these difficulties. So one of the issues I have written about is Article 52 of the European Convention on Human Rights, which concerns inquiries by the Secretary General of the Council of Europe. So under the convention, Article 52 allows the Secretary General at any time to ask states to furnish them with information on any issues regarding the convention. And I have argued that especially in states of emergency derogation cases, the Secretary General should actually exercise this power, and PACE has explicitly adopted a resolution asking the Secretary General to do so. Unfortunately, it hasn't been used much, only in black site detention cases and some other, excuse me, similar cases. But I'm thinking, especially in the context of rule of law and democratic backsliding, it also allows them to more timely, but also more generally address these more structural issues, because it's not concerned with an individual fact of a case. So I would appreciate your reaction to that, any thoughts you may have, or how it may help address some of these broader issues. And then on the Novaya Gazeta case was mentioned, there's a very interesting opinion by Judge Pavli there, which I assume you have engaged in your paper with, and he explicitly raises this issue of democracy and whether through this legitimate aim, and I'm adding my thoughts on this, whether sometimes we actually legitimize some illegitimate concerns of governments by simply dismissing or either not engaging or engaging exclusively with the arguments of the states, but not really questioning whether those are adequate at all, or just more holistically think what these aims mean. And others have written also in the context of security, the court never would ask whose security, what security, but just sort of respond directly to the issue raised by the government. So that's also another aspect that which connect to both this aspect of how, what are your thoughts on Pavlis, or in general this idea of the court zooming out and engaging more with structural issues, and whether the court itself is actually equipped to deal with these cases, or at least we should expect more from other institutions within the Council of Europe. Thank you.
It's a question. Some questions are popping up. So let's take two more. Just to the left of, I'll come back to you, and then Amal first, if you'll introduce yourself.
Hi, I'm Amal Sethi. I'm from the University of Leicester, and I have a targeted question for Edward. So obviously I've not read this, so I want to be, careful in asking it. You did have this slide about potential, objections, criticisms that such a role would have. And your presentation, the way I today at least saw it, was a bit more like a descriptive project, in some sense that this is kind of the things that we can do, a court can do. But I also sense like a bit of normative aspect, where this is like a desirable last resort option for courts to do in pursuit of protecting democracy. If I get that wrong, please push back. So with this assumption, perhaps my question is this, that I don't deny that this is like a good kind of intervention. It's a desirable intervention. But my worry is that it will shift the dial too little, and in most cases, the compliance will be really low. And if courts start doing this, it could perhaps kind of actually destroy the legitimacy of these courts, because they can do in some areas really good work, but where in these high profile cases where they have like very low success rate. You know, you were talking about kind of that it can build trust in the people. I worry whether people will stop trusting it because in the most important issues they see nothing happening. So I would love your at least response to that. How do you see this issue? Because personally, I don't think it's a bad thing. I just worry that it can actually erode these courts more than what the current level of erosion is happening with public trust.
Thank you. And there was one last question here.
Thank you. Jasper Grommendijk, Radboud University, Nijmegen. I have a question for Alain. I'm looking forward to your book. Just wondering, do you have any views on the Court of Justice of the EU, whether it's adopting a similar approach? I'm especially interested, or at least I know this Romanian judgment that also Dragos might know, Inspectora Judiciară, in which it adopts this more contextual approach, whereby it is not looking at, let's say, the law as such, because indeed states might write it indeed in very neat terms from the perspective of legality. It looks perfectly fine, but it really looked at the wider context in which these laws, these measures were taken, and also the intention behind. I've not really looked at the case law of the court more in depth, whether it has followed this approach, but I'm just curious whether you have any reflections on the Luxembourg court. Thank you.
Thank you. And I'm going to abuse my position because I want to ask a question from Kirsty's paper, which is how does one get that message out there, the message that you so powerfully delivered today? You did a brilliant video, I recall, on YouTube as a response to the Rwanda ruling. So please do a video on this, for example. But no, please do. But how do we, the phrase is shift the dial here on this? I fear now Lord Wilson's report here will be seen as the last word on the subject of Article 8. Some people, I fear, don't want to be persuaded in any other way. Could the Joint Committee on Human Rights, for example, undertake an inquiry into Article 8 and a general question of, you know, how can we take forward your really important contribution? So we can come to that in a minute, but perhaps we could start with Edward and go along the line and sort of go back to Kirsty, and I'll leave you to sort of pick out which elements from the various questions we have you see as more appropriate, and we'll need to be relatively brief, please.
Perfect. Should I? Oh. Thank you. So I will be addressing two of the questions, the one on Rule 39 and, of course, the one that was pinpointed on me. So on Rule 39, the Inter-American Court has addressed structural issues through provisional measures, which would be the equivalent of Rule 39 measures. However, they're still pending to engage with more structural types of democratic issues. They have, however, managed to address politically sensible issues through provisional measures, achieving the suspension of parliamentary debates, to remove, to impeach judges and to impeach determined members from high courts in general, who were being seen trying to be impeached because they were stalling types of issues that were of importance to the government in that moment and to the political majority, and they were surprisingly successful in being implemented. Mostly grounded on the fact that then the courts had a new tool on how they were going to be able to withstand and to some extent, stop a little bit the pressures that were being exerted by the legislature. So there's an interesting case study there. I haven't discussed it. I mean, I haven't seen them in the specifics about them, but there is something. And there is a interesting paper by Clara Urbano on transformative provisional measures, that although the title is very ambitious, I think it gives an interesting description of how it works. Now, on Amal's question, so yes, and there is always a room that there's going to be, you understood everything perfectly, yes. Your assumptions were correct. And to be fair, I argue that this is a desirable intervention, but moreover, I think that it's an intervention that might actually legitimize even more the Inter-American Court of Human Rights. The only thing is that it requires us to change a little bit the framework of how we're going to assess the effectiveness of that measure. There's a paper very interesting by Aníbal Pérez Liñán that he argues that we should be not only measuring effectiveness through impact, but also defining impact in 3 levels. The first one is changes in narratives. The second one is institutional mobilization. The third one is impact on the ground. The third one is a very long shot of something that has to be achieved. Of course, the remedy is going to be fully effective once, in this case, democracy has been reinstated. But what he argues is that we should be addressing effectiveness as to how the tool of the structural remedy is starting to be used within the broader, let's say, community of practice, the broader framework of individuals that are part of this. So when we engage with international actors and they're using the judgment, it seems that it's working. When domestic actors are using the judgment, it seems that it's working. So it's sort of that. It's a nuance on trying to change the focus on compliance in these types of cases because of that exceptional nature. Thank you.
Thank you.
So I will answer the question about this temporal issue, and I will add that it's not only important for temporal need to stop these processes, but it's also good for the court for consistency, because it seems a bit arbitrary that that's only single judges who are deciding the case, and it doesn't seem that there is a general approach of the court. Although you are also right that there are priority rules, so the court does have priority. For instance, it needs to consider cases in which people are deprived of liberty, or it's this right to life or Article 3 cases. And under this priority list, it's also this endemic and systemic cases. So the court has everything in its power to streamline this approach. And honestly, it's a bit odd why, for instance, eco defense wouldn't have been decided much earlier, or why now, when we already submitted the application also regarding the civil society in Georgia, the court doesn't seem to be very eager to use the interim measures. And we also do know that, like Judge Pavli or former judges like Nussberger, very, very often pushing the court into this direction. Yeah, that's, I think, and in terms of if the court is most appropriate or other measures, I can tell you that in the context of Georgia, even the court, I don't know how effective, even interim measures are questionable in terms of effectiveness, but certainly no other body is effective, because Georgia was, so Georgia's delegation rights from the Parliamentary Assembly was suspended. Still, the rhetoric is super hostile, and our government, the only thing that they are looking for is that they get legitimacy not as a democratic state, but as an authoritarian state, which is already consolidated. So you need to deal with it as an authoritarian state. So, yeah. I'm sorry.
Yeah, so maybe to start with Ed's question on timing. So this is exactly a question that I think my project very much struggles with, because when we talk about timing, I think we're entering the realm of effectiveness. And effectiveness, I think, when we get into effectiveness, I think there are two issues that come up. The first is that it's an empirical question to start with. So that takes, I think, the investigation, at least my investigation, into, I think, a different realm in terms of methods and tools for investigating these questions. And the second one, which I think is also a difficulty of mine. So I sometimes worry about jumping to and cherry picking some doctrinal tools that the court could make a better use of. So maybe Rule 39 could be an example of that. Or in my own project, I've looked quite a bit at Article 18, that I think has also been very much the focus in terms of designing a doctrinal response. I think these could be remedies, but I think they're also symptoms of the problem, because we don't really get back, at least my project is looking at the court's equipment in terms of concepts and principles. So my investigation is more principled than it is empirical in that respect. And that's why in terms of doctrinal concepts that I think are doing a lot of work, democratic society, for example, is my focus. So I'm absolutely aware that I'm also dodging the question to a large extent, but I think effectiveness, I think is I think a difficult concept for my kind of framework to work with. When it comes to the comparison with the Court of Justice of the EU and the recent Romanian case, so I think the picture is relatively simple for me, is that the CGEU can not only control the sword, but it also control the purse. So it has, we have seen in the case of Poland, it can impose a financial penalty up to, I think it was 1 million euros a day. This is a very kind of coercive, if you wish, means of triggering, trying to trigger compliance. I think in the multi-layered framework of the European Court of Human Rights, things are vastly different. And I think that's why the court has a higher burden of persuasion. And again, I think that trying to bring this back to my own project, the key question is whether the court, maybe speaking also to the issue that was raised in the audience, but also by Edward, which is whether the court is actually naming the problem. And I think to that extent, my answer is absolutely not. So the concept, the conceptual framework that is being used is very much one that is derived from the 50s. I don't see any new conceptual innovation on the part of the court. However, and that coming back to Kustrom's question about the Secretary General of the Council of Europe, which happens to be Swiss like me, he actually innovated conceptually because he's now raising the concept of democratic security. Okay, so I'm curious about how this is going to be play out, whether there will be in some stage the court speaking a little bit more closely to the problem of authoritarian populism in one way or another. I think I'll stop there.
Thank you.
Thank you. Well, thank you very much for your very kind comments and generous suggestions. I mean, I would welcome anything that, any initiatives that allow the debate to take place on a better informed footing. I don't know if there's necessarily a single solution to that. I will certainly take on board the suggestions that you've made. I think those are really helpful ways in thinking about how to take this forward. I think that part of the difficulty is if we think about what's happened previously, if we think about kind of the independent report on the Human Rights Act and then immediately the sort of the consultation on the Bill of Rights after that, which kind of, as they were described at the time, like two ships passing in the night. There's no, I think, kind of silver bullet to this, but I do think we have to take all measures, and I think academics do have a role to play in making sure that there is transparency and accuracy when stating what the legal position is and what the issues are. So I'm definitely keen to pursue that. Thank you.
Hope you do. So, thank you very much. I think time is up. We're a little bit over time, in fact, but this therefore gives me the opportunity to say, I'm sure we'll thank our speakers in their regular way, if you would put our hands together. Sincere thank you to you all. That's an excellent start to today's session. we have some coffee. We don't need it because we're so stimulated by this. This will stimulate us even more. And this will also be an opportunity perhaps for people to take forward discussions with individuals who just presented, if nothing else. So we have a coffee break and we resume at 1/4 past the hour. So 20 minutes are built in for a coffee break. And we look forward.